Well, we got a hearing this week, February 2nd, 2023 at 1:30 Colorado time. These are the motions to discuss. Defendants previously filed a motion of change of venue and a motion to waive jury trial. Those motions remain outstanding. The court did not receive any motions by the deadline imposed by the court. Now, I was looking through all these motions and all this stuff. Her attorney hasn't done nothing. He is not returning emails. He's not returning calls. What's really going on here? I mean, come on. Okay, defendant previously entered a plea of not guilty by the reason of insanity. Defendant has been examined by the CMHIP and the court had received the report regarding her eval. Then she had a second one. The court understood the exam was to take place at the end of October, beginning of November. Defense counsel represented a report and would be received 30 days of the exam. The court has not received a report regarding a second eval. The people have filed their, whatever that is, P34 motion regarding that matter. Jury selection is scheduled to commence on March 20th, 2023. The court will discuss the mechanics of jury selection in that case. Counsel should be prepared to discuss the anticipated length of the presentation of evidence for the trial. At some point, the proposed veneer will need to be advised of the potential witness in the case. Witnesses. Counsel should be prepared to discuss the motions. Okay, the court will discuss media restrictions with counsel. So hopefully we'll be able to watch this, but what is her attorney up to here? What he's not doing here. So I come to read the people's motion here, and what is her legal team up to? All right, motion for discovery concerning the defense expert, and that was Dr. Lewis. You people remember that? Okay, March 11th, 2020, defendant was charged with murder in the first degree, child abuse resulting in tampering with a deceased human body, and tampering with physical evidence of Gannon on January 27, 2020. The complaint was amended March 20th, 2020, adding several other counts related to the death of Gannon. On November 4, 2021, defendant entered not guilty pleas to all counts. Counsel for the defendant gave oral notice their intent to introduce NGRI. The court ordered an evaluation for her at the Colorado Mental Health Institute. The case was set for jury trial March 28, 2022. On February 11, 2022, defendant changed her plea to NGRI. And the counsel for the defendant stated on record they have good cause to change the plea as they have an expert that reviewed material. There appears to be some, I don't know what that's supposed to be. They whited that out. Okay, counsel did not indicate his expert has not done the insanity eval yet. The court ordered eval at CMHIP, trial date 28/2022. On August 4, 2022, the court received a report from CMIHP finding that defendant was legally sane at the time of the crime. Defendant filed a motion of a second sanity plea, requesting that Dr. Lewis conduct the exam. On August 25, 2022, the parties were in court to discuss the logistics of the second eval, and the defense counsel informed the court on the record that an eval report is expected to be completed within 30 days of that expert. Oh, I remember that. Dr. Lewis has been reviewing materials for a while. I remember that. Okay. October 13, 2022, defense counsel withdrew the request to have an EEG be done at part of their expert eval, and stated in chambers to the court that the prosecution team, they anticipate to have their experts eval would be complete by December 1st. The parties agreed to set the case for current jury trial on March 20th, 2023. December 27, 2022, the undersigned sent an email to both defense counsel requesting when the report would be available from Dr. Lewis. The undersigned left a phone message with, I call them tortellini people, on January 11th. Okay. Undersigned reference email and phone call message have not been returned as of the time of the filing of this motion. Can you believe that? A copy of the report of the defendant made at the instance of the defense shall be furnished to the prosecution in a reasonable time. So they can look through that, I'm sure, is what they're saying here. Colorado rule, and they go on about the rule, that prosecuting attorney be informed of any reports by experts in connection with a case as well as underlying facts, data supporting the expert's opinion. The intent of this section is to allow the prosecution meaningful information to conduct a proper cross-exam. The extent that the defense intends to call witnesses at trial, the people are requesting to have names, notes, reports, underlying facts, that the experts' opinions, in advance to the trial. Okay. The jury trial is set for March 20, 2023. Over 3 years after the death of Gannon, the people respectfully request the Honorable Court to enter its order regarding the defense to provide people with such information. I mean, really. Okay, so that makes sense. And here's the letter. What's the date on this? December 27th. Good morning, Josh and Will. I hope your holidays are going well. Please let us know when we might anticipate a report from Dr. Lewis regarding insanity eval of Letecia. And they haven't heard nothing. Wow. Wow, wow, wow.